And wonderful. All right, well, thank you everyone for joining us tonight for the latest installment of our RadTech speaker series. I'm Albert Fox Kahn with the Surveillance Technology Oversight Project, and we're so delighted this month to be joined by Rebecca Wexler, who is the leading expert in the topic we're discussing tonight, which is the intersection of trade secrets and surveillance. And just a bit of background, so S.T.O.P, the Surveillance Technology Oversight Project, is a New York-based surveillance and privacy group. We focus on the intersection of local government surveillance and civil rights, looking at everything from facial recognition to drones to social media monitoring and all the different ways that these tools are reshaping the way that our communities are policed and the ways that our cities are governed. RadTech is a monthly speaker series that we partner with. You can find more about RadTech on the Meetup website, and we really hope that you subscribe to join us for future events as well. So just a bit of background about Rebecca, which will not do her justice. So Rebecca Wexler is an assistant professor of law at the University of California, Berkeley School of Law, where she teaches, researches, and writes on issues concerning data, technology, and criminal justice. Her work has focused on evidence law, criminal procedure, privacy, and intellectual property protections surrounding new data-driven criminal justice technologies. And she's also the faculty co-director of the Berkeley Center for Law and Technology. I know there are a bunch of other accolades I could add to that list, but we'll leave it there. Rebecca, thank you so much for joining us. Oh, are you muted?
Yeah. Oh, there we go. Albert, thank you so much for that generous introduction, and just to be a part of this. It's a really exciting speaker series that you have. I'm such an admirer of S.T.O.P's work and advocacy that I've been following for a couple of years now, and I'm just thrilled to be here today.
Well, really the pleasure is all mine. And so before we get into sort of the area you focus on most at the intersection of trade secrets and surveillance, let's just go through the basics for people who haven't heard about it before. What are trade secrets? What is this weird doctrine that we somehow have under American law?
It's pretty weird. It is definitely a weird area, a little corner of the law. But trade secrets came out of a kind of mixture of concerns around ethics in business relationships and other concerns around propertizing information. And so there are these two different theories of what trade secrets are. They are today a form of intellectual property, so a form of protection that you have for information to stop people from stealing your business development secrets and using them in a competitive product. And that's their ultimate goal. Like, the policy behind the law is to protect people from business competitors stealing their stuff and using it to set up competing businesses. The reason to go back and say it's got this weird origin story that's a mixture of, in legal speak, tort and property, is to say that there's not a 100% right here, the way there is, say, in even comparing it to more traditional forms of property, like you own your house. You own your house, you have a right to stop anybody that you don't know from coming in. You have, they call it a right to exclude the world. Intellectual property is a little bit different because information's got, or there's a child outside. I don't know if you can hear this person who's very unhappy, but intellectual property is different because, you know, if you duplicate information, then the person who receives the copy and the person who has it to start with both still have a full copy. So it's not like your traditional property situation. And as a result, there are these kind of gray area doctrines. Trade secrets is one of them, and it balances a developer or originator's own interest in keeping business secrets for themselves with the public's interest in having follow-on innovations and disseminating knowledge. It balances that by making what I would call a porous right. So trade secrets are leaky, and that's part of the social contract that's the law to begin with. They're leaky in, for instance, somebody gets a product off the market and reverse engineers it and figures out how it's made and built. That's totally legitimate. Now, all of a sudden, they can take that information and they're allowed to use a competing product. So build a competing business. So that I could just geek out way more on it, but that's maybe even too in the weeds. I'm not sure.
No, I think that's really important sort of framing for it, because it's really, it is this thing that it's very strange when you think about it, because it takes the exact opposite approach of patent law when you think about it, which is all about how let's make this stuff public, and in exchange you get these legal rights. And here it's about, okay, we're going to give you these weird porous protections in order to help you preserve this strange competitive edge. And it's always seemed like a very perplexing thing to have just as part of the legal system.
Yeah, and actually, Albert, you made me realize I didn't say the most important thing, which is that trade secrets are supposed to be secret. So comparing them to patent law is exactly the right contrast. As Albert said, for patents, the social contract is the opposite. You got to publish the information to the world in applying for a patent to the PTO. But then once you do, if you get the patent, you have a monopoly on that, where you can stop anybody else from using it for a certain period of time. Trade secrets are the opposite. You get the protection so long as the information is secret, is commercially valuable by virtue of being secret, and isn't obviously isn't ascertainable from the market, and that you have taken reasonable precautions to maintain the secrecy. And so if you fail on any of those, you don't get the protection. Once it leaks, your right is over. And so that's part of how this part of law balances the public interest with the private interest, is saying, well, we'll let you keep it for as long as you keep it secret, but when it's no longer secret, you can't have any IP in that anymore.
Yeah, and if we want to think about a couple of the arguably positive cases before we delve into the horrible ones, one I always like to think of is candy makers. They've had the same recipe for, a Hershey's bar for, decades and decades. The patent rights would have ran out, generations ago, but because to the extent they're able to keep that candy bar recipe secret, they get to hold on to that legal protection in perpetuity, effectively.
Totally. And now I'm just, and who is it that, right, Jeannie Fromer at NYU has written this wonderful piece about candy makers as some of the origins of our current trade secret doctrine. Other people attribute it back to trade guilds in the Middle Ages and what have you. But our current doctrine maybe comes from these candy makers that Albert is referencing. I think she has an article on Willy Wonka's chocolate factory, and
oh, that's such a good premise. So let's talk a bit about sort of the history of trade secrets and criminal justice. What, from the work you've done, what is the earliest point at which these two sorts of areas of law start to intersect and come into a collision?
It's really pretty recent. Well, they start to come into a collision earlier, but the kind of particular doctrinal evidence issue that I focused on is much more recent. So I will say the earliest waves of litigation around trade secrets in criminal justice technologies that I'm aware of are around early DNA technologies and breath test devices. Mm-hmm. With early DNA technologies, criminal defendants were often trying to get access to, and I'm not an expert on exactly what aspect of this technology it is, but something to do with kits, testing kits. It's not computer software at this point in time. It has something to do with amplification kits for how you run the sample through machines and get an electropharogram, a result of what DNA is in the sample. And for some reason, they wanted to be able to get access to those kits, and there were trade secret claims that were made in response to try to challenge their discovery. Those weren't, for some reason, iterated. They weren't argued in the evidence law domain, just curiously. The next wave of litigation, also that didn't focus on evidentiary privileges specifically are these breath test devices. And so people start challenging whether software, this is where software comes in, might be running with a bug that says the blood alcohol, or sorry, your breath test alcohol is higher than it actually was. And it's interesting that that's the place where there starts to be a lot of litigation on the trade secret issue in software, because the political economy of those cases is that people from all sorts of communities with all sorts of kinds of privilege and wealth end up being arrested for DUIs. And so we have situations where there's well-resourced defendants who are seeking to challenge these technologies. And they happen to be the cases where we first see strong arguments about source code disclosure, and in New Jersey, in particular, litigation that actually results in exposing bugs and problems with the software that changed standards for how police could use it.
And I think that's such a key theme we see with a lot of these civil rights fights in the surveillance space. You know, some of the only good recent wiretap holdings come from white collar cases where, you know, you saw, you know, invasive surveillance tools that are overwhelmingly used against poor defendants of color being used against, you know, wealthy investment bankers. And suddenly you saw the, you know, Second Circuit willing to intervene and actually say, okay, no, this might be going too far. But that seems to be a big pattern here with when the courts are actually willing to push back, or when you have, you know, actual defendants with the resources to challenge these types of practices. Let's turn to the sorts of bugs you mentioned in the source code in that breathalyzer. And because like with a lot of these technologies, you know, you hear about someone, they blow a certain amount on the breathalyzer, it's put out there as objective fact, but that objective fact isn't always what it appears to be.
Yeah, totally. I will say, gosh, I didn't review the actual New Jersey Supreme Court findings there. And so I'm not super remembering exactly what the bugs were that they found. But what I can say is it's a New Jersey Supreme Court case. They ended up having a whole expert analysis of the code that the New Jersey Supreme Court ordered. And then I think found that, my recollection, but if you want to dig into this, please double check me, is that there had to do with something if there was like a sample that was a breath that was too strong or something like that for the sensitivity of the system, it might spit out an incorrect result. That's my vague memory of exactly the bug that they had found in that case. But I know that it led to a change of regulation for the use of the tool.
Yeah, and I also have not reviewed that case in quite some time, but I think that also is something that we'll see as a bit of a pattern, that you can have a tool that where you have evidence that it works in a subset of cases or within certain parameters, but you don't have the sort of robust testing prior to when it's deployed by police to know that this actually is going to work every single time along the lines that are described, and you won't have these outlier cases where people are wrongly accused by, you know, software that's just getting it wrong.
I'm so glad that you brought it up and phrased it that way, and I think it gets to a really deep issue that you're pointing out, which is when we run validation studies in a lab, we can't anticipate all possible failings of end use cases. That's something we know in science. That's why we sometimes do studies in labs and sometimes do studies, you know, in vivo or whatever in situ, I don't even know the Latin words, but say of observing animals in the wild versus observing animals in a lab. Like, you can't anticipate everything when you set up a controlled experiment and validation study. And so you need to have some safeguards for the end user or the end individual who's being convicted based on the use of the tool to challenge its application in that circumstance. Upfront safeguards, upfront standards, upfront validation studies, they all matter. They're really important. It's not an either or. Those matter. And we have an adversarial criminal legal system because we're committed to letting individuals and empowering individuals to challenge the government's case in any one instance. I care so much about this. And, you know, there's so many reasons to have that. It's similar, I think, to the idea of crowdsourced security in the open source movement, that we're not going to anticipate every single vulnerability. The more eyes on something, the better. It's also, but this is why we have these individual due process rights. And I hear a lot of people say, why should we make sure that individual criminal defense counsel can do their job by analyzing source code or some other complex information that requires expertise to examine? They don't have the resources. We shouldn't be focused there. And I like to point to the story, since you all are surveillance folks, I think you're familiar with stingrays, but I like to point to the story of Daniel Ridgemaiden, who exposed for the world that police all over the country were using stingrays without informing the courts, without getting proper warrants. And he did that by litigating pro se from a jail cell in his own individual case. So the cool thing about automated technologies in the legal system is that when you do have one individual, whether it's an attorney like Jerome Greco, who is like a special expert on these issues, or it's another just individual defendant who's a special expert on these issues, and they find a bug, a flaw, some undisclosed technology, some bad practice, because these tools are being used consistently throughout the justice system, those individual cases can have scalable benefits to improve our legal system nationally.
Completely. And yes, major shout out to Jerome Greco on that point, who is an amazing attorney for the Legal Aid Society, but also one of our co-hosts for this event series, and here with us tonight. And I do think that's a really powerful idea, that the more eyes you have on any one device, the more eyes you have on any one system, the more likely you are to find these errors, especially when they're errors that are outliers, especially, or when you're trying to identify systems that are being hidden from the public, you know, by design. And you know, I believe it's a Radiolab episode that goes into the story behind, you know, how stingrays were discovered, and just the skepticism that attorneys had when this information was being put together. And, you know, but this was someone whose case was being impacted by it, and he was relentless in putting together the evidence and bringing a lot of visibility around the issue, around these fake cell towers, you know, for the entire country. So I was hoping that you could describe some of the evidentiary privileges that come into play when you're looking at, you know, how these different systems are being used at trial.
Yeah. So this is the area that I've spent most of my time focusing on, which is how I think that these trade secret claims are coming up today, and moreover, how they're actually changing the legal rules for the worse. So it's not just that people are making these arguments and the courts are processing them and rejecting them as they should, but they're making the arguments, and in my view, they're altering. Developers are so powerful, and technology developers and software developers and the tech industry is so powerful in our world right now, that the kind of legal arguments that they can make can push the law to evolve in their favor. And one way that's happening is with these evidence rules. So an example that I've spent most of my time focusing on are, and I know you guys are interested in biometric surveillance, are forensic DNA analysis software programs. And so here we have software systems that are being used to analyze DNA samples from crime scenes that are complicated enough for some reason that human analysts are unable to assess them using traditional DNA analysis methods. So it's not your single source, huge pool of blood. We know how DNA works. We've been doing this for a long time. It's tiny bits of DNA where there's been degradation from environmental exposure or contamination from other sources, or mixtures of lots of people's DNA. We don't even know how many people's DNA, 1, 2, 3, 4, 5, who knows? And these private developers have built computer software systems that they claim can run an analysis of these complex DNA samples and produce a statistical reading of how likely it is that an individual suspect's DNA is included or not included in that sample. So that's the case scenario where this is coming up. And what's happening is defendants say, I want to see whether your system does what you say it does. Mm-hmm. You know, I want to know not just the biology behind it. I want to know whether it's been properly coded up in the software. We have examples of some of these systems producing contradictory outcomes on the same sample. You know, you get tested with one software system and it says it's inconclusive, and another software system says you're excluded, you know, and this could make the difference between a conviction or an acquittal. So defendants understandably want to scrutinize everything about these tools, and developers are pushing back and they're asserting their IP to block our normal subpoena and discovery rules. And that, if I can, and I'm talking too much, so I want to hear Albert talk, but I want to emphasize that one point, because a lot of times people think that if we don't have some extra special protection for trade secrets, like if trade secret owners don't get a special privilege to block criminal defense requests for information, which is what they're asking for, that somehow that's going to mean that it's like wild. Now defendants will be able to get anything they want without any kind of standards, and will descend into some world of harassing and abusive subpoenas and gray mail and all these kinds of worries. Gray mail is a concern where people are sending, you know, abusive requests in order to just provoke higher costs for continuing the prosecution and get the prosecutor to drop the case. But the thing is, we have this problem for all information in the criminal legal system. And so our existing baseline rules already account for it. It's actually pretty darn hard to get a criminal defense subpoena to begin with. So you have to show that you're seeking information that's relevant. You aren't going on a fishing expedition. You're not engaging in this kind of bad faith, abusive conduct. If there is sensitivity in the information, you get a protective order. The information can be disclosed with limitations on subsequent use and subsequent disclosure. These are the solutions we have for like a whole array of sensitive information. We have in criminal proceedings, you know, perhaps some people on the call know this even better than I do, but you've got, you know, alleged victims' medical records going to criminal defense counsel under protective orders. And we decide that, you know, or sometimes there are some special protections for that kind of information above and beyond the standard baseline, but we get, you know, very intimate personal communications between friends and family members. We compel parents to testify against their children in court under these same baseline standards that apply to all subpoenas and defense discovery demands. And so what trade secret owners are actually claiming is that they should get better than what we give everyone else. They should get special treatment, what we call it an evidentiary privilege, so that those normal rules are no longer good enough, and that they should have to, defense counsel who wants to get access to this information should have to make some far more onerous showing.
I feel like there are all around the country, silently, countless defense attorneys saying amen and applauding right now, because it's like, no, I think this is one of the odd dynamics of the American legal process right now, that we have such opposition to any real ability for criminal defendants to challenge the evidence against them. You know, we saw this in New York with discovery reforms, you know, over the last few years, where, you know, simply the idea that, you know, defendants would get to quickly see the evidence against them instead of being asked to wait until the day before trial, you know, that somehow that was tilting the playing field. I think people don't understand just how much the deck is stacked against defense attorneys with most of this information. It just seems so, you know, callow of the tech firms to then swoop in and use this both to protect themselves from competitors. But I think that another major factor is the fear that they'll be, you know, shown to be charlatans in some cases, because there's a lot of firms out there selling a lot of technology with the promises that it worked, but not a whole lot of evidence to back that up.
Yes, I'm going to say amen to that. And add, like, I think that's totally right. So what we're seeing is developers are claiming that having to comply with a criminal defense counsel subpoena would threaten their entire business model. I haven't seen the transcript yet, but I heard through some other attorneys I spoke with that there's a lab in Alaska that's taken open source code from a EU-funded public software system that does forensic analysis on DNA, added some sort of wrapper to it, is running it from Amazon Web Services and telling courts he can't comply with defense subpoenas because that business is his retirement fund. I know I haven't read the transcripts, but this is what I've heard about that, and it doesn't surprise me because I've plenty of other examples of companies claiming exactly the same things, not with the retirement fund exactly, which is particularly upsetting, but the same basic rationale. I have a commercial interest in this information, and that commercial interest is more important than the due process rights of the criminally accused, and frankly, the legitimacy of the legal system for the public as a whole. So to your point, Albert, I agree. Why are they so concerned when we're talking about disclosing information to attorneys? Mm-hmm. They're officers of the court. They're subject to professional sanctions if they misuse the information. And companies disclose very sensitive, very valuable trade secrets under private non-disclosure agreements all the time. Mm-hmm. So the remedy we give people for a terrible situation where somebody does steal your trade secret and set up a competitive business is that you can sue them. Mm-hmm. That's what trade secret law says. You can sue them. And that remedy is totally available here. So the more you poke at the developer's argument that this is somehow a threat to their existential existence of their business, it really just falls apart. If somehow defense counsel were gonna take the code that they're getting to represent their client, somehow switch careers and set up, go and be a competitive forensic software developer instead, they can sue, just like everybody else can sue.
And that is something that really profoundly disturbs me as well. The idea that you are remaking a process that is not really, that has never lived up to its promise of protecting individual defendants the way we should. But you're taking that process and you're degrading the core function of our courts for the criminal justice process in order to provide a remedy that already exists through civil law. And the idea that you're essentially saying that the rights of these corporate actors are more important than the rights of the people standing trial, which is just, I think everyone knows neither of us would think is an argument that deserves much credibility. I just want to pause because we're a little more than halfway through and would love to invite people to ask questions using the Q&A function at the bottom of your screen. And you know, I want to ask for a few other examples of the systems that are being used, just so people have a better sense of the range of systems this comes into play with. But one thing that keeps coming to mind for me, especially as you're describing that lab in Alaska, is we've seen this play out badly with much less sophisticated technologies in the past. And you know, the first case I ever worked on as a law student was when we had the Massachusetts drug lab scandal. And we saw that there were thousands of falsified cases potentially where people were being put away in prison for years because of analysts who were claiming that substances which were not drugs were falsifying the amounts. And you know, people went to jail for that, that they had to review that, you know, really a huge number of cases. But it just shows the tremendous power that these labs, that these vendors have to shape the narrative that jurors end up believing.
I didn't know you worked on that case. That's amazing. Wow. I mean, I watched the Netflix series. And
just too. Because I did not help litigate the case that invalidated. I just was helping people whose cases had been impacted by it.
No, that's huge. That's huge. I mean, yeah. I mean, in any way involved with that case, cleaning up the mess of it.
Yeah, but thank you for that. No, that was just bizarre. But let's turn to the sort of the array of technologies that we see out there. What, you know, obviously DNA is a big one, especially given how much juries defer to it. But what are the other technologies where trade secrets are coming into play?
Yeah, so the scary thing is that there are these trade secret assertions in all kinds of surveillance and forensic technologies that are being introduced throughout the entire legal system. And we have, you know, as a society, just turned to more and more privatization. And that's happening in the criminal legal system as well. And so the more that we privatize stuff, the more these claims are coming up, although public entities can also and do also sometimes claim trade secrets to block. But so it's DNA, there are developers have used trade secrets to try to prevent disclosure of information in face recognition technologies as well, although they're not as much being litigated in that same procedural posture. So it's not coming up in the same evidence domain. Stingrays, there were trade secret claims to try to compel the police not to reveal any information about that technology in court. And then another place that's been litigated so far is in risk assessment instruments. And so those are, again, instruments being used, developed by private entities. They're being introduced in pretrial proceedings, in sentencing, in parole. And the developers there have also claimed that they aren't going to reveal information about how the tools work. So it's really any kind of commercial product. I think another reason why these claims are increasing is because the Supreme Court has made it harder to get patent protection in software systems. And so developers are turning to trade secrets as their new IP form of choice. And that means the more that we have software systems coming from primarily private developers into any stage of the criminal legal system, the more of these claims we're going to see. So I anticipate, I haven't seen cases challenging this on an evidence front anyway, but I anticipate automated fingerprint analysis. You've got automated bullet forensic marks, gait analysis, iris, any kind of biometric system developed with software, there's a chance that the developer is going to claim that they have some IP right to withhold information.
So my head is exploding on a number of levels right now. Well, first of all, as someone who has thought that the idea of software patents is obscenity for many years, like the idea that eliminating software patents is getting us this horrific outcome just seems like really a perverse twist. But then one of the things that really confuses me is that a lot of these underlying forensic science disciplines are controversial on their own, and so it's adding this other layer of ambiguity and uncertainty. And so I'm just thinking, there's an amazing opinion from Nancy Gertner that goes into the issues with a modern ballistic evidence. There's been similar reviews, after there was a high-profile case of a false positive back in, I think it was 2006, that led to a national review of fingerprint analysis. And so it's unclear for a lot of these systems if you could ever have a human or automated match that is conclusive. And so then the idea that you're using that system and then on top of that, refusing to show how you're actually doing your work, it feels like it makes it impossible for anyone to have their day in court.
Yeah. Thanks for bringing that up. Like, I completely agree. Right. I mean, we had this 2009 report out of the National Academy of Sciences, 2016 PCAST report under the Obama administration saying we have a huge problem with forensic science in this country. We have a huge problem with fraud and inadequate safeguards against fraud. And we also just have a huge problem with overclaiming and poor methods that aren't validated, methods that aren't foundationally valid, that aren't scientific in any possible definition of the term. And unfortunately, since we have such faith and juries have such faith and we as a society have such faith in technology, computers and software, I think that some of the push towards automation is being justified as, well, this will be better than the humans, without reckoning with the fact that humans write the code.
Yep.
So it's really a tricky thing to say. Some of the people that are supporting the technology say, yeah, there's these huge problems in forensics and this is the way forward to try to eliminate those or minimize those. And yet they're introducing new problems without any standards. There's no clear requirements for quality assurance for software deployed in criminal cases.
And that 2009 report from the National Academy of Sciences that you mentioned, that was just, I think that should be required reading for anyone who's interested in this field, just because it went through all of the different, forensic sciences out there. And I should put sciences in quotation marks, because when it went through and evaluated them, it found that the only peer-reviewed, evidence-based scientific method we had that actually was scientific by the academic standard of that term was DNA. And that other than that, everything was premised on assumptions based off of these like odd accreditation bodies where you have professionals in those disciplines self-accrediting and accrediting each other without any true independent evidence or evaluation that works. And so when you're thinking about, oh, well, I will go and make an automated system that makes that better, you're stuck either with making a lot of subjective determinations how you make an algorithm that tries to do it better, in which case you have the same issue that you don't have any evidence that the choices you're making work, or B, you have this situation where you're feeding it lots of training data from past cases, knowing that those decisions in the past are completely suspect. So there isn't a good development model in any case.
Yeah,
sorry,
that's exactly, no, it's exactly right. I mean, it's exactly right. And so it's totally, I mean, so I think, Albert, what you're pointing out is this problem that a lot of these methodologies have grown up not through, as you said, not through science, but through policing. And so what are the incentives for police when they want to build a case, or law enforcement more generally, including prosecutors when they want to build a case? And it's the asymmetrical incentives that they're incentivized to develop methods that lead to convictions. whether or not they're accurate. And unfortunately, it's structural asymmetries, it's these structural imbalances of power all the way down, because what we have now are developers making products that they sell commercially to the same lopsided version, the law enforcement side of the criminal legal system. But we have an adversary system. And so law enforcement's goal is to find and investigate guilt and get convictions. Law enforcement has no duty to investigate innocence and get acquittals. I was kind of floored by this when I dug into it, because I had this idea, well, we've got an adversary system and prosecutors, argue for convictions and defense counsel argue, but I didn't actually realize there's zero constitutional, statutory, or even formal ethical duty for prosecutors to investigate innocence. It's not their job. So if we have the law enforcement side has all the money, they're the paying customers for the developers are going to build technology that serves the goals of the paying customer. And they're not going to build technology that serves the contrary goals of finding innocence or poking holes in the government's case. So it's just layered and compounded. And
I know. I think that's such an important point, that the customer here are the police departments. It's not the public. It's not the court system. It's not anyone invested in justice in any sense of the term as the outcome. It is people who are looking for a tool to fuel convictions. But thankfully, we have a lot of public defenders and defense attorneys out there on the opposing side, and there have been some successes lately. I was hoping you could tell us a bit more about some of the innovative strategies that people are using to actually push back, even despite the best efforts of Silicon Valley and prosecutors.
Yeah. Well, I want to give a huge shout out to Julie Fry and the New Jersey Public Defenders, because they just won a pretty amazing and great opinion out of the New Jersey Supreme Court called Pickett, where the court comes out and says, on the trade secret issue specifically, trade secret law is about business competitions. It's not about due process. It allows you to stop your business competitor from stealing your stuff. It doesn't allow you to stop a criminal defendant from getting due process. I haven't seen an opinion certainly not from such a high court, that's so clear about that dividing line. The other parts of the opinion are equally impressive, and they say defense counsel really has to be able to evaluate source code in a forensic software system in order to determine the reliability and challenge the reliability to see whether the results will be admissible in court. But since we're here to talk about trade secrets, I want to highlight that case, New Jersey Pickett case, has just really excellent language in there, drawing a clear dividing line. The other thing I want to flag that I'm super excited about is a different type of strategy that defense counsel's just been beginning, and I think will hopefully happen in more cases, which is when developers assert that they have some kind of intellectual property right to not comply with subpoenas. Another route to obtain information about forensic software systems is from cloud service providers. So, it's possible if you try to subpoena a developer and they say no, try to subpoena that same material from GitHub. Maybe their code is stored in a repository there, a private repository, not an open source one, but maybe you can subpoena GitHub for that information. And GitHub certainly doesn't have a trade secret in that source code. So that's one alternate route. Maybe somebody will subpoena Amazon Web Services for the code from this Alaska lab. I don't know if anybody's done it yet, but I'm hoping they might do it soon.
And I love this approach just because this is the approach law enforcement has been taking to target defendants for so many years, that they use this runaround for the Fourth Amendment called the third party doctrine, where they'll go and they'll say, well, we're not taking the information from you, so we're just going to take it from a private company. And, maybe we are getting it from that company so we don't need a warrant, or maybe we're purchasing it outright from a company, as they're doing with a lot of these geolocation data services and others. So they use the fact that our data is held by all of these third parties in order to circumvent the Constitution. And now this gives defense attorneys a way to circumvent the trade secrets protections in order to go after the people making these systems, which is just, that seems brilliant.
I'm pretty excited about that. This is a new wave of litigation. I'm hoping it will expand. It's pretty exciting stuff. I mean, at the point, I guess I would focus on that, Albert, you've raised a really crucial point that law enforcement has power to access lots of this stuff. And so it really is just an asymmetry here. They have power to get stuff from tech companies. They have power at procurement to compel companies to disclose stuff or not use their tool. They have power to choose which cases they're going to introduce these new systems in, and make sure that any test cases have pro-prosecution facts, or facts favorable to their long-term agendas. So there's just asymmetries all the way down, as I was saying before. But that's right. Law enforcement has been getting this stuff from tech companies. So how about defense counsel getting this stuff from tech companies?
Definitely. And just want to pause again to ask people, if you have questions, please use the Q&A tab at the bottom of your screen, and you can just type your question in right there. But I know, in addition to litigating this and hopefully getting one day a really good a national ruling that'll help across the board, one of the areas you've worked on is legislative response. So I was hoping you could tell us a bit about some of the bills that you've worked on that would address this issue.
Yeah, totally. I'd be happy to. So there's been real interest in Congress, and in both houses of Congress now, actually, to try to do something new again, which would be pretty great. But I started talking with some folks from Congressman Mark Takano's office way back in 2015, I think it was, that I started talking with them about defendants' access to source code. And then they were interested in doing something about the problem, and companies asserting trade secrets to block it, but didn't have kind of staff on board to do anything for a couple of more years. They ended up getting a fabulous person, Emily Paul, who was a Tech Congress fellow in this really important program, to come for a year and work with them. And she ended up just taking this project on to say, what would be the best kind of federal legislation that could address this issue, and helped, draft. And I contributed, many other people also contributed to that bill that came out in 2019 called the Justice in Forensic Algorithms Act of 2019. And that bill had two components. One was the kind of issue that I've focused on around trade secrets. Let's not have special treatment for trade secrets in federal evidence rules. Let's just treat trade secrets like other kinds of evidence. Developers can move to quash a subpoena if they want. They can make all the same arguments anybody else can, but they don't get special entitlements to change the burden or make more onerous. And then the second part of the bill would impose some standards on what kind of forensic software systems could be used in criminal prosecutions. And they would require some sort of NIST testing. So the National Institute of Science and Technology would do some sort of testing standards there. Those standards part of the bill are not actually, that I was not involved in contributing to those, but I think they're a really good idea. And now there's a possibility of a reintroduction of that same bill out of Takano's office with some amendments, new and improved version 2.0. and also the possibility of a Senate companion. And so it's a really hopeful time for legislation. Yeah.
And so if people have a few minutes on their hand, is there anyone they should be calling out to? Maybe Judiciary Chairman Nadler, who we're in your office, Chairman Nadler, we're in your district, just as a reminder, but anyone else you think people should reach out to?
Gosh, I don't know. I don't know the answer to that, but I can ask.
Yeah.
I can ask and then send it your way. It would be great to have your community, you know, supporting by making phone calls. And
definitely. And one of the things I always wondered about is, you know, you made the really good point early on that people often push back by saying, how are, you know, line DAs going to have the resources to look through all of these materials, all of the source code? You know, I think in the Pickett case, they were saying there were 70,000 lines of source code for that one system. You know, flash forward 2 years, you know, Justice in Forensic Algorithms Act is law. We see, you know, parallel bills that have been passed by every state. We have, you know, an amazing Supreme Court ruling that found a federal constitutional right. And so now everyone in America has the ability to challenge the algorithms being used against them and to look at behind the trade secrets. What's the model you think that can help there in like providing the resources and expertise? You know, the NIST model, the independent verification sounds great, but do you think we'll see resource pooling amongst different DA's offices? Will we see some sort of nonprofit strike? How do we actually empower defense attorneys to use that access to fight back?
Great question. So first of all, like part of these arguments about, oh, there's 170,000 lines, or in Pickett, however many lines, you just said however many lines as it would, I forgot in Pickett, how many lines?
I think it was 70,000. I could
70,000. So it is like these arguments are being made alongside claims that defense counsel should have to review the code with a pen and paper or pencil and paper, right? And so from that perspective, yeah, it'd be really hard to review 70,000 lines of code with pencil and paper, but that's an absurd condition. And we have software programs that can help you review the code, that can identify flaws and common bugs, that could identify things perhaps that the companies really would like not to be identified, such as maybe they themselves have copied some public domain code and got that incorporated in there, or copied some code that's got a license that they're violating and they don't want that exposed. So there are automated detection tools already. And this just exposes the fact that these arguments are, you know, it's hard to even think that they are, that they could be made in good faith. So just flagging that point, I don't think it takes as many resources to review these programs as some people are claiming. That said, there's huge need for more resources for defense counsel, huge need for centralized sharing and pooling. And there are some folks who are leading the way in that. You know, Legal Aid Society's got a digital forensics office that Jerome is running. They also are leaders in DNA forensics. They run an annual conference, Questioning Forensics, where they help, you know, just the defense bar, criminal defense bar generally, to be more aware of this. Some of my colleagues at Berkeley in our student Samuelson clinic are interested in helping provide sort of pro bono legal services to criminal defense counsel on technology issues. And I'm trying to get, as a computer scientist at Berkeley, to also kind of develop a pro bono culture. Because Albert, you know, lawyers have a pro bono culture. You know, pro bono hours, part of getting passed to the bar. And then you go to law firms, and these big firms are recruiting young lawyers based on their opportunities to pro bono. Well, how about having our tech communities also have a culture of pro bono service, pro bono clinics out of the computer science department in Berkeley, pro bono projects out of major technology companies. I think that's another possibility there.
Oh yeah, we're going to have a lot of follow-up conversations on that point, because we know that there are a lot of people who are working in the tech industry who are not thrilled by the consequences of the code they're working on and the products they're building and how it impacts the world more broadly. And so I think there is a huge appetite to use these skill sets for a social justice mission. And I also do love the thought of having a day where we fund our public defense offices enough that you can then have not just the pro bono response from the software community, but suddenly an actual market response where people see it as just as profitable to build the tools that debunk the forensic algorithms as it is to build the tools that are being used to put people in jail, sometimes wrongly. Oh, and lastly, I also want to give a shout out to the Innocence Project that's been doing amazing work just in this field more generally, and I know has also done a lot to educate public defenders all around the country.
Completely agree. Thank you for flagging them. Yeah, they're some of the most inspiring lawyers that I've ever met, focused on software accountability in the criminal legal system.
Well, I know we only have a few minutes left, but I want to have one last call for questions if people have any issues they want us to address. Otherwise, I want to ask, for anyone who sort of ends up on a jury, who ends up somehow coming across this type of evidence in their lives, who hears about it on the evening news, I'd love to, just as a takeaway, have how credulous should we be when we're hearing these claims? How skeptical should we be when we're being told that a certain person was a match to a crime scene sample or to some sort of predictive determination?
Yeah, you should be skeptical. If you hear somebody's a match, you should be very skeptical. That phrase is one of the red flags that the kind of exposés of problems in our forensic science has exposed, that a match, a claim of a match, isn't verifiable. It's not there's no numerical scientific foundation for a match. What do they mean by a match? And when you push expert witnesses to testify, who are testifying about this, some of them will say that with 100% certainty, this sample is this suspect's DNA or fingerprint or whatever. And that's also a completely baseless claim. So anything that you see a match, you should be very suspect for. But in general, I am worried that juries have a tendency to trust automated systems and computer systems and technology that sounds fancy. And unfortunately, we can't have that level of trust in these tools right now.
Completely. So for those of you who are watching, especially any of you who end up on a jury, please remember, a match may not be what it seems to be. Well, Rebecca, thank you so much for joining us. It's such a pleasure to have you on. It really always such a fan of the work you're doing. And
Same.
For everyone who's tuning in, thank you so much for joining us. We'll be back for the next installment of the RadTech Speaker Series next month, and you can check out our prior episodes on YouTube and our website. Thank you again so much.